Welcome everyone to our next Master Lecture in the GoFly Master Lecture series. It's my pleasure to welcome Raja Maharajh from Pratt Whitney. As everyone knows, we are so pleased to have Boeing as our grand sponsor, and we are joined by corporate sponsor Pratt Whitney, as well as over 20 aerospace and STEM organizations around the world. In this session, Raja Maharajh, Vice President and General Counsel at Pratt Whitney, will be lecturing about legal guidance to protecting your IP and sensitive technologies. He is Pratt Whitney's Vice President and General Counsel, responsible for leading Pratt Whitney's legal services team, with overall responsibility for the company's legal matters, as well as contracts, corporate ethics, government compliance, and government security. Raja brings more than 20 years of legal and engineering experience to this role. He has held a number of positions of increasing responsibility since joining the UTC Legal Department in 2004. Prior to being named to this current position in November 2016, Raja was the Vice President and Counsel for Pratt Whitney's large commercial engines business. Prior to joining UTC, Raja was an associate at Brazenman and Drangle in New York and held positions in engineering at Madame Alexander Dahl Company in New York City and Maidenform Inc. in New Jersey. He holds a Bachelor of Science degree in Industrial Engineering from the New Jersey Institute of Technology and received his Juris Doctorate degree from Seton Hall University. So it's my pleasure once again to welcome Raja.
Hi, thank you. Let me just get the presentation up. Okay. So good afternoon, everyone. My name is Raja Maharajh, and I'm the General Counsel here at Pratt. Really excited to talk about IP and give you a little crash course on intellectual property. Do our best to get through the 4 basic areas of intellectual property and why it's so important to companies. But before I do that, I thought I'd just give you a little bit about my background and explain why I'm so passionate about intellectual property. I started off my life as an engineer, as mentioned before, went to NJIT in Newark, New Jersey, got my bachelor's in engineering. After that, made the decision that I was going to work during the day at a manufacturing company and go to law school at night. That was a great decision for me because I had the opportunity to get some real life work experience in engineering while getting my law degree at night. After graduating law school, joined a small little intellectual property boutique in New York City where I was prosecuting patents and handling some IP litigation. Now, having that engineering experience really paid dividends for me in the cases I was working on. That manufacturing experience and the engineering experience I had allowed me to understand the documents I was reading and help guide cases in different directions. After spending 4 years at the firm, I took the plunge and went into corporate America by joining Pratt Whitney. Now, when I joined Pratt, I had no idea that this was going to be the most amazing company to work for in the world. You see, as both an engineer and a lawyer, there's no better place to be. You've got cutting-edge jet engine technology here and some of the most complicated and complex legal issues in the world that just really makes it exciting for whether you're an engineer or a lawyer, and especially if you're both. But that's enough about me and why I'm so passionate about this. Let's jump into a little bit of intellectual property. What I hope to do today in this little crash course is give you the overview of what intellectual property is and why it's so important to corporations. We're going to start with patents. Oh, sorry, wrong slide. There's 4 areas of intellectual property. There's patents, trade secrets, trademarks, and copyrights. The one that we're going to start with, and it's probably the most relevant to the GoFly program, are patents. It's the one that engineers work with the most. It's the one you get the most exposure to when you're at a company. So to talk about patents, I thought I'd give you a little bit of history on how the patent system started, and it'll give you a better understanding of why the patent system is structured the way that it is. So let's go all the way back in time to the late 1500s. And there was a gentleman named Peter Chamberlain who invented the obstetric forceps. Now, at the time, when women were giving birth to babies that were breech, both the mother and child would usually die. They really didn't have a good chance of survival. But the Chamberlain family had developed the forceps and were able to help with these births. What they did, though, was they kept it a trade secret. They kept it private. And for over 100 years, they were able to keep this family secret and help people, but nobody else could benefit from it other than the people that were being helped by the Chamberlain family. At first, they would only help the super wealthy because they were the ones who could afford to have them come and help. But over time, they were able to have some of the brothers and other family members who used it spread out, but it was still a very limited population. And they went through great lengths to protect the invention. Now, no one knows for sure, but it's rumored that what they would do is they'd carry it in this very large box to make it seem like it was something larger than it was. They would have bodyguards. They would have it covered in cloth so nobody could actually see what the box looked like, and try to disguise it as something other than forceps. And when they actually got to the room where somebody was actually giving birth, they would ask everyone to leave the room. And once everybody left the room, they would then blindfold the mother and use the forceps to help the delivery. And they had a very, very high rate of successful deliveries where both the baby and the mother were healthy after. Now, this went on for over 100 years, and they went through great lengths to protect it. And sometime in the 1600s, the English royal family said, hey, this is really something that we could benefit from, the society could benefit from. So what they did is they passed the statute of monopolies. And in 1624, they cut a deal with the Chamberlain family and said, look, could you disclose this to society so that people could use it after your monopoly? And during that monopoly, you could probably get royalties, or you could license it, you could allow people to use it, but it's something that would benefit society. Plus, maybe there's a way to actually improve on it. So in 1624, they issued the very first patent in England, and the forceps was that patent. Now, fast forward hundreds of years later, and not a lot has changed. The basic concept, the basic principles of patent law hasn't changed much. The first article of our US Constitution actually grants Congress the power to issue patents. So it's still a government right that's actually granted. And we, in the United States, had our first patent issued in 1790 to Samuel Hopkins for the method of making potash. Now, a lot of things have changed since 1790. There are many more patents going through the system. There are processes and procedures that are now put in place, and it takes a little bit longer because you have many more people applying, but the basic principles are still there. If you disclose your invention, in exchange for that disclosure, you're going to get a monopoly for a period of time. And it's 20 years today from the time that you actually disclose the invention. There are basically three elements to the patent system in the United States. One is the disclosure has to be one that the inventor shares the best known way of achieving the invention. So if the inventor knows a couple of different ways to actually achieve it, they have an obligation to share the best way to do it. It also, at that disclosure, anyone who reads it is allowed to read it and use it, and they can take that and actually improve on it, and after the patent is expired, they're allowed to actually go and use it. In exchange for this, it's the same deal that was cut back in 1624. The inventor gets a 20-year monopoly to make, use, or sell the invention. That's basically the deal that you're getting. What is patentable? Well, a patent can be any subject matter that is new and useful. It could be a process, it could be a machine, it could be composition of a material, or an improvement of anything there. The new and useful sounds simple. It gets a little tricky when you're in the patent office because that's where the fight is. There's always an argument as to whether or not this is something that's new or something that's useful. But as a general rule, if you hear somebody say, hey, that's a great idea, there's probably an invention in there somewhere. Sometimes the simplest inventions can be the greatest advancements in technology. So I mentioned that there's a 20-year monopoly, but what does that really mean? The patent doesn't give you carte blanche to actually make, use, or sell the invention. In fact, sometimes you can have a patent that may fall under another patent, and in that case, you can't make your product. The patent right gives you the right to exclude others. It's a little confusing, but let me see if I can explain it with an example here. So you have company X, that gets a patent for a foldable knife. And what that means is company X can stop anybody from making a foldable knife. Now, company Y comes along and they make a multi-purpose foldable knife. And what I mean by that is, you can see the example here, they come up with ways to add different blades and a saw and screwdrivers and even a scissor. And The patent office says, hey, this is unique and this is new and this is useful, so I'm going to grant you a patent. Well, even though company Y gets a patent for their multi-purpose foldable knife, they're still not allowed to make it because company X also has a patent for a foldable knife, and it happens to cover company Y. So company Y's got this great invention and they say, this is great, and they go out and try to sell it. Company X can actually sue them for infringement. That's a very simple way of looking at it. It really gets complicated when you start looking at different compositions of material, aerodynamics, shapes of blades in aerospace. So the bottom line is the patent gives you the right to stop others from making, using, or selling something that's covered by your patent. It doesn't give you the right to exclude it, to use it. The other question that always comes up is, when should you file for a patent? Now, today, that answer is a little different than it was years ago in the United States. Years ago, the US used to allow you to get a patent if you're the first to invent. Now, it's just like the rest of the world. You have to be the first to file. So it's critical that as soon as you figure out that you have an invention or you think you have an invention, you really need to get to a patent agent or patent attorney, share it with them, and work with them to get your invention filed with the patent office, because the sooner you do that, the better you are protecting the rights that you have. The one unique thing, now when the US did that, they started going more towards the international standards, which is first to file. The one nuance that the US still has that the other jurisdictions don't have is you still get a 1 year, I'll call it a grace period, we call it disclosure rule, where if in the US you use it or you sell it or you make it, you still get 1 year to actually file it with the patent office, where everywhere else in the world, if you go and sell it or you use it publicly, you really lose your right to actually file for that patent application. The patent process is really not complicated, the patenting process. So applying for it, when you go to your patent agent or patent attorney, there's a couple of things you can do in advance to help with that process, make it a little smoother and actually save some time. There's 5 things I like to look at that I ask people to do before they actually come and talk to a patent attorney. The first thing is prior art. And what that means is when you come up with an invention, there are other papers you've researched, there are other products you've looked at, there are things that you've done to help get your invention to where it is. And it's really important that you gather all of that information, you put it together, and you share it with the patent office when you submit your application. What that does is it allows the examiner to get a little bit of a head start on figuring out, is this something that's new, unique, and different than what was done before? The other thing you want to do is you want to share with the patent office is, what problem does your invention solve? And that really helps them with the useful part. So the new part, the prior art, helps them with that. The useful part is, well, what are you trying to do? What are you trying to solve? What is the problem that came up that caused you to create this invention? The next thing you want to do is really document and put together all the information you have on how your invention is actually different from the past technology, from the past things that were made, past things that were sold. What are the benefits of the invention that you have? And lastly, the 5th thing is, I mentioned this before, you really want to write down a description of your invention using drawings or write-up. And it's so critical that you actually share the best known way to achieve the invention. That's really all you need to do to get to a patent attorney. Now, that's only half of the process of preparing it. Now the patent attorney or patent agent will take all of that information and they'll start writing up the application, and they'll work with you. They'll go back and forth to make sure you're comfortable as the inventor that what they're describing is truly your invention. Once that process is complete, it gets filed with the patent office. And that's where the waiting game starts a little bit. Once in the patent office, there's no way to tell how long it's going to take before they respond and provide some sort of initial answer. It can take months, it can take years. It really all depends on the area of technology in which you file the application. Once it's reviewed by the patent office, by a patent agent at the office, they will do one of 2 things. They'll respond and say, hey, this is a great idea, it's a great invention, and here's your patent. That doesn't happen often. It's in fact very, very rare that happens. I haven't seen it happen in my career. What normally happens is the patent agent at the patent office will say, hey, look, I don't think this is an invention, and here's why. It's either too similar to something that's been done before, or it's obvious in light of something that's been done before. And that's where your patent attorney or patent agent is responsible for coming up with the arguments to convince the patent office that, no, 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 your invention is unique. Your invention is different. Your invention is something that should be granted a patent. That process can go back and forth on multiple iterations. And there'll come a point in time where the patent office will just make a final determination. They'll either say, hey, I'm done. There's no invention here. And that's the end of it. And there's an appeal process for that. Or the patent office will say, you know what? You've convinced me. Maybe we can tweak some of your claims a little bit, but we'll grant you a patent. That process can take a long time. It typically takes 3 years, but don't be discouraged if it takes a little bit longer. There's nothing wrong with that. What I will say is that all the inventors I've spoken to have told me that it's just an amazing thing to be an inventor and actually have your name listed on a patent. And that's something that's going to be recorded in the patent office forever, for eternity. So that's really the summary of patents. Let's move on to another area that I think is a little bit cooler than patents. It's trade secrets. And you can see the definition of trade secrets here up online. It's really something that is held secret that gives you a competitive advantage over your competitors. When I think of trade secrets, I think of like corporate espionage, and it's just kind of cool. It's like almost like the CIA is working on something. I have listed up here 2 of the most famous trade secrets in the United States, and I'm going to tell you a little bit about both. And the first one did involve a little bit of corporate espionage. So Coca-Cola has been known to have their original formula kept in a vault for decades now, that not many people have the combination to. It's rumored that only 2 people have the combination to this vault, and they're not allowed to be in the same place at the same time. Whether that's true or not, Coca-Cola keeps all of their formulas as trade secrets. And back in 2005, they were about to launch some new formulas. And one of the administrative assistants working at the company, who was disgruntled, found out what some of these formulas were because she supported the global branding division of Coca-Cola. And this is a public case, so you can research it online. What she decided to do was take that formula or a couple of those formulas and try to sell it to competitors. Now, what's funny here is even though she was thinking of doing that, she knew she had a non-disclosure agreement. So she thought she'd get a little bit of protection by getting a friend to do it. So she found a friend of a friend who had just come out of jail, and she convinced that person to send a letter to a bunch of different companies to try to sell the new Coca-Cola formulas. Well, this person did that, and it got to Pepsi company. Now, Pepsi's Coca-Cola's fiercest and largest competitor. When it came into Pepsi, they initially thought it was a joke. After looking at it a little bit further, they realized that somebody was trying to steal Coca-Cola's formula and sell it to them. Now, they did the right thing. As a good corporate citizen, they took that letter and they handed it over to the FBI. Now, the reason they did that was, even though they were getting it from somebody else and even paying for it, it's still illegal, and they knew that. They knew they couldn't use that information, that they could get into a lot of trouble. They could be responsible for a significant amount of damages to Coca-Cola if they actually went and bought that. So they handed it over to the FBI. The FBI pretended to be Pepsi. They contacted the middleman and eventually made their way back to the administrative assistant. Well, to make a long story short, the case went through, and she spent 8 years in a federal penitentiary because she was trying to steal trade secrets. Trade secrets are very valuable to a company, and they're not, and by misappropriating them or sharing them, you're not just setting yourself up for civil fines, but you can also go to jail. It's criminal fines as well. The second most famous, well, in my opinion, the most famous trade secret is the WD-40 formula. Now, WD-40, I happened to be working at a firm before coming to Pratt Whitney, and that company, that firm represented the WD-40 company. WD stands for water displacement, and 40 is the 40th iteration of the formulas that they tried. So it could have been WD-28, 29. It just sounded really cool. They got lucky. It was WD-40. What's interesting about their formula is only one person knows it. There are others who have access to it, but it is locked away. And the person, and this is going back 15, 16 years, so it's possible that it's changed a little bit by now, but back then, they had one person who would control all of the ingredients going into a large vat and mix a batch and then have it bottled or canned. They did that so that nobody would know what the formula was. They were so afraid of it getting out. Now, as the attorney who showed up, I didn't get access to it, but I said to them, can't you just figure it out by going to the procurement department and figuring out all the ingredients that they actually buy? And they said no, because they were buying ingredients from multiple products and no one knew which ingredients or how much of each were going into the WD-40. I just thought that was really interesting that these two companies went through these great lengths to keep the trade secret. And a trade secret's no different than any other secret. The best way to protect it, don't tell anyone about it. Or tell as few people as you can about it. So the next area of intellectual property that we're going to touch on a little bit here are trademarks. Now, trademarks are a brand name used to identify the source of goods or services. It's that simple. When you hear or see a trademark, something comes to mind. Either something good, something bad. If you had a bad experience with that product, maybe you're indifferent because you know about it, but you haven't really tried it. Or there's some marks that you've never heard of because you've never used that product and you've never seen it before. Here's some of the more iconic trademarks in the United States. Now, some of them have words that provide the company name and others are just a picture. But in every instance here, if not all of them, you quickly know what product that is being sold. And more importantly, you have this quality associated in your mind with the mark. For instance, Starbucks. Someone will quickly think that it's either really good coffee or really bad coffee, depending on your taste. I'm guessing the Dunkin' loyalists out there are probably going to lean more towards bad coffee, but they have spent a lot of time and money in their mark. And you know when you walk into a Starbucks store, the quality of service that you're going to get. You know the feel you're going to get in there. You know how you're going to be treated. You know the words that they use to actually order the coffee. All of that is associated with the company trademark. If someone else were to use that same mark, they'd really expect the same quality and level of service that they would get from an actual Starbucks store. That holds true for every mark on this page. If you look at McDonald's, you know exactly what you're going to get when you walk in there. You look at the Nike Swish sign, and first thing that comes to your mind is sports or shoes or running shoes. You look at Chiquita, and most people don't say banana. I always say the word banana after they say the word Chiquita and the famous Mickey Mouse ears. I mean, those are the most. That's one of the most iconic trademarks in the world. When you have a trademark, it doesn't have to stay the same forever. And this is important because trademarks, you develop a reputation, you invest in it, and what you can do is you can change them over time and still keep some of the value in the mark, depending on how much you change it. Now, if you take a look at the McDonald's mark, they took some drastic changes at the beginning. They were called McDonald's Famous Barbecue, then they went to McDonald's Hamburgers. It was in 1953 where they really started just focusing on the name McDonald's, and it was in 1968 where they actually came up with the golden arches and decided to use that as their mark, which has really held the test of time since then. McDonald's has put a lot of time and money into their mark, and it's one of the most famous marks in the world. It's been said that it's the most recognizable mark in the entire world. It's one that their reputation and the money and time spent in it has proven to work. I'm going to give you a little example of why companies are so sensitive about all the time and money they put into a trademark. So let's say I decided today I wanted to open up my own fast food store, and I decided to call it McNeil's. I just decided to use the M because I wanted to work off of the McDonald's mark a little bit. And I decided to use the same M that they have with the golden arches, much like the McDonald's logo. Well, at that point, I'm getting the benefit of all the time and money that McDonald's invested into their brand. Plus, McDonald's is losing sales to me because consumers might be going to McNeil's thinking it's getting the products from McDonald's. Now, it sounds a little confusing, but the bottom line is the trademark is there for the original and the owner of the product. Others using it is an infringement of that trademark. If I get the benefit of that trademark or I confuse people with that trademark, I'm the one who's actually infringing, and it's not fair to McDonald's. So that's how the trademark laws is set up to prevent that sort of confusion. It's really set up to protect the rights of the owner, to prevent the confusion in the marketplace, to prevent deceiving consumers, and to prevent the dilution of that trademark. So the last area of intellectual property are copyrights. And copyright protection is set up to protect the original works of authors in any tangible medium. That can be a picture, a book, an essay, video, audio recording. And today, it's actually set up for 95 years from publication. We talk about 70 years from the death of the author. That's also a term. But most publications today are done under a corporate name, and you get a little bit more time on that when it's 95 years from publication. Let's talk a little bit about what is probably the most famous copyright in the world. It's so famous that it's believed this copyright, this film, has actually driven the changes in the United States copyright laws. So let's go back to 1928, and Disney releases Steamboat Willie, which was the first introduction of Minnie Mouse and Mickey Mouse to the world. And at that time, Disney got a 56-year protection on Steamboat Willie. Now, 56 years was with some of the extensions that they were allowed under the existing laws. Fast forward, that would actually get them protection to 1984. Well, Disney, with the power that they had, they were able to convince Congress through their representatives to overhaul the copyright laws in the late 1970s. They were so worried about Steamboat Willie running out of copyright protection that in the late 1970s, they actually convinced Congress to revamp the copyright laws, and it allowed Mickey Mouse or Steamboat Willie to be protected until 2003. Well, fast forward. In 1998, with only 5 years left of protection on Steamboat Willie, Congress again rewrote the copyright laws and extended the protection to 2023. It's 2018 this year. Next year will be 4 years before Steamboat Willie gets the protection is expired. We'll see if there's another change in the copyright law. I don't know. It's hard to tell right now. We haven't seen anything, but it's very possible that somebody comes in and tries to extend it again just to protect Steamboat Willie. Now, even if Steamboat Willie's copyright expires, that doesn't mean Disney can be copied. Let's not forget that Disney has a very powerful trademark, and their trade dress are so powerful that their brand will be protected for many, many years to come, even without Steamboat Willie being on the copyright. So just in summary on copyright holder rights, the copyright holder can reproduce the work, prepare derivatives, distribute it at their, they get to control all that. And it's really simple to protect the copyright in the United States. All you have to do is put a marking on it, a C with a circle around it, the year that you did it, and your name. So why does IP matter? Why do companies spend all this money on intellectual property? Well, they do it to force competitors to spend money and time to develop their own IP with no guarantee of success. Here's a little story about TiVo and the Dish Network. So TiVo sued Dish Network for patent infringement, got a $74 million judgment and a permanent injunction, which prohibited Dish Network from using those patents. Well, Dish Network went and they spent a year trying to design around the TiVo patents, and they failed. And they were still actually offering their service. They were found in contempt of court by not honoring the permanent injunction. They were sanctioned. They wound up spending $500 million in a settlement with TiVo to do it. Now, Dish Network had two choices at that point. They could have paid the money to TiVo, which was great for TiVo, or they could have exited the market, stopped offering the service, and then tried to get back in when the patent expired. They made that conscious decision, the financial decision, to go ahead and pay the settlement money and keep in a competitive environment so that they wouldn't fall out of the game. They must have thought that if they left for the time that the patent was still open and came back after it expired, they may not be able to get back into the market. The other way you get some value out of intellectual property is licenses, right? Disney, actually, they license their name for $50 billion a year in revenue. IBM has a patent portfolio that it licenses every year, and they get roughly $1.2 billion a year. And you can also sell it. So you can sell your IP. Nortel sold about 6,000 patents back in 2011 for $4.5 billion. AOL sold 800 patents to Microsoft for about $1 billion in 2012. And that's just some of the ways that corporations really, really benefit from investing and developing their intellectual property. Now, what you guys are doing is amazing. The GoFly program is such a challenging and interesting program. It's one that I think is long overdue. So happy to hear that we're getting down closer to the end now. I wish everyone luck. Hope you guys do come up with some really cool ideas, and maybe you can work with somebody on patenting those ideas and protecting them. And I'd also like to take a moment to just thank Boeing for their amazing sponsorship and partnership throughout this entire program. With that, if anyone has any questions, I'm happy to take them.
Great. Thank you so much, Raja, for that incredibly informative lecture, and also for sharing those really amazing historical cases for us to understand how all of this works. So a couple of questions that we have coming in is, if, let's see, applying for a patent is expensive, what jurisdictions, countries are important to file in, especially for aerospace? And what countries can I forgo, and what countries do I need to absolutely file in?
So in aerospace, it doesn't matter whether it's aerospace or anywhere. You always want to file in the countries where your competitors are, where that technology is being used the most. With Pratt Whitney, we always file in the United States, obviously, because that's where we are. We also file in Europe, and we file in some other jurisdictions. But you really want to go where the aerospace companies are. Right now, I would say that, and I'm not going to catch all of the countries here, but I'll tell you just off the top of my head, the United States, you've got most of the European countries, especially Germany, England. You also want to make sure you don't miss Japan, China. There are several jurisdictions that you really want to catch, because that's where the larger aerospace companies are.
Okay. And could you talk a little bit more about provisional patent applications in the US? So the question following is this a cost-effective way to obtain priority rights? What are the advantages and disadvantages?
I'm sorry, I didn't hear the first part of the question.
About provisional patent applications.
Yeah, so provisional patents, I believe, are still just used in the US. What that does is it's really just a disclosure that goes into the patent office. It just buys you time. It doesn't, if you have the funds to do it up front, my advice would be to always go ahead and get a full application in. But the provisional patent is one that if you just don't have the money today and you just need to buy some time, you can file that. It keeps the cost down initially. But you're still going to have to run into that expense a year later. I think it's still a year that you have that the provisional patent's on file. And if you don't do it within that year, you lose that date.
And can I file a patent myself, or do I need an attorney to do it?
You can, so legally you can file a patent application yourself. We don't recommend it. Even when I was in private practice, we would, encourage people to use a patent attorney, and you can do some things to help keep the cost down by participating a little bit more. But the law does allow you to file for the patent application on your own.
And how do I search for previous patents? You were talking about that in your lecture.
Yeah.
Do you recommend searching? How do I discover what patents are already existing?
So searching is really an art, and there are search firms out there. Even patent lawyers don't do the searching anymore. It's an art that, really good patent searchers, that's all they do. And they do it online now. Many years ago, they used to actually go down to the patent office and go through all of the boxes of patents, but today it's done online. I don't recommend you do it on your own, because it's such an art that if you don't know what you're doing, it's easy to miss stuff. But they do have really good search firms out there that's all they do. They charge you a fixed fee, and they'll provide you with prior art. Now, even if you do that, there's no guarantee that you're going to get all of the prior art, but it's a really good start.
Is there a place that you can point our teams to, Raja, about where they can find these search firms, or what they should be looking for in a search firm?
Yeah, so I don't have a place now, but we can get that information. One of the mentors that we have in the GoFly team, on the GoFly program, is our chief IP counsel, and I can have him find out, where, maybe get some links to places that people can go to get searches done.
Great. So we can follow up with people following the lecture.
We'll get that.
Thank you. Should we file for utility patents and design patents? What are the benefits of each?
So a utility patent is just a regular patent. The design patent is actually a patent of the image. Unless you're selling something and it's the design itself that's selling and not the usefulness of the product, design patent really doesn't help you that much. Design patents help you if what you're selling is the image and not the usefulness of the product. The utility patent is where you should normally go, especially in aerospace. In fact, I don't know if Pratt has any design patents.
Okay. How do I protect my IP and my trade secrets when speaking with VCs and other potential funders and investors?
Okay, so the first thing you do is you make sure that you only disclose the elements of the trade secret that you have to, but before you even do that, you have to ask them to sign a non-disclosure agreement to make sure that they know that it's secretive, and you protect it as much as you can. You share as little as you can in order to get them comfortable. But the key to that is putting it under a non-disclosure agreement.
So how much should I actually share with potential funders? Like maybe if you can offer some details around the description of the design, the technicalities, what exactly should we be sharing and not sharing in order to protect our IP?
Well, the best thing to do, honestly, is to get the patent application filed first before. In an ideal world, you would file a patent application and then go and try to get funders and people to help you. If you're not in that position, you're not able to do that, or you have a trade secret, then you really want to share as little as possible. And it's hard to, there's no rule. It all depends on the type of technology, the type of information you have, and how comfortable the investor is with the information that they're getting. Most investors are going to want more, and you have to fight and negotiate with them to share less. The less you share, the better off you are in protecting that information. But ideally, the best way to do it in the aerospace world is to file for your patent application and then go work with investors.
And how do I, so it seems that trademarks seem a bit easier to get than a patent. Can I file a trademark myself, or should I also get an attorney to do that?
It's the same thing. You can legally go ahead and file for a trademark application yourself. You can do it online. There's actually pretty good instructions at the United States Patent and Trademark Office on how to do it. Filing for it is not that as difficult in the trademark world. What is difficult is if they start trying to negotiate with you. If the patent office says, well, there's these other marks and how does it work? You really need somebody who understands the law to help you with that. And that's why at that point I'd go to a patent attorney or trademark attorney. But it is something you can do yourself.
Can you talk a little bit more about how we as a team can go about filing a trademark? Just tell us a little bit more about the uspto.gov. What exactly can I do there, and what's the process of me utilizing that website?
So at that website, if you go to the trademark section, it'll tell you exactly what you need. Now, if you've got a distinct design in your trademark, you'll need to upload a picture of it. You'll need to explain what it covers. There are different types of products and different areas that each trademark covers. You also need to explain, how is it a trademark? How did you actually develop the identification with your mark? You can't just go, you could just go and file a trademark up front, but it's of no value unless you've actually developed it and you've shared it with people and people know that it's a real mark. Otherwise, you're just putting something in the trademark office. But at the end of the day, you're going to have to, at some point, explain that consumers now associate this mark with a company. And all of that is listed out on the trademark website of all the elements that you need to submit in order to file the application.
And so once I filed an application with the U.S. Patents and Trade Office, let's say in the United States, is it good in other countries, or is it like a patent and I need to file in multiple countries?
Now, and I'll be honest, I'm not as familiar with the trademark laws in other countries, but typically a trademark is only good in the area where it's known. So let's say you even file it in the United States Trademark Office, and you only use the mark in Connecticut, then it's of no value to you in California, because the trademark has to be used in the area where you're trying to protect it. And I believe that the rules are the same in foreign jurisdictions, but I don't want to give you a definite answer because I honestly don't know what the process is in other jurisdictions when it comes to trademarks.
And are you aware of, in other countries, do they have similar sites to the USPTO? Are there resources where we can find where our trademark, let's say in our country, where we can find a website like that might be helpful for us?
Yeah, and every country is different, but foreign jurisdictions do have, I don't know what they are off the top of my head. I know that the European Patent Office has a website, and that's for patenting. I don't know what each individual country has, but typically they do have their trademarks registered online and a website where you can go to and research it.
Okay. And can foreign nationals file a patent application with USPTO without the help of an attorney as well?
Yes. Okay. There's no restriction on who files the application.
Mm-hmm. Let's see, next question. Should I have all team members sign IP documents so that the company owns the IP and a team member can't take it?
So when you say team member, most companies do have agreements when you come into the company that requires you to not share that IP that you're developing within the company outside. Mm-hmm. And it's something that almost every company in the United States has, and that company will actually own the intellectual property.
So just to clarify then, it's not necessary that each team member is part of the IP documents that are being filed, but as long as that's being included in any documents making them part of our company, then it's okay. Does that make sense?
Say that again? I'm sorry.
Yeah, so just to be clear then,
yep.
All of our GoFly teams are made up yep. of several members.
From different companies, right?
Yes.
Okay.
So then each of those team members does not necessarily need to be part of the IP filing, as long as their designation as part of the team and their agreements with that team is clear that the IP belongs to the team or the company that's being formed.
So when it comes to a patent in the United States, everyone who was part of the invention, who contributed to the invention, not just they could not just being on the team, but if they were contributing to the invention, they have to be listed on the patent application. They have to sign the patent application. Okay. You can't exclude anybody. In the United States, that's the rule. I don't recall what the rule is in foreign jurisdictions, but I know in the United States, if someone contributed to a patent application, they have to actually sign the patent application.
Okay, great. Thank you for that clarification. Should I make sure that team members, that the team has all team members sign confidentiality documents?
So I don't know what the rules of engagement are with each team member and what they initially signed to come onto the team. I would go look there first to see whether or not there's confidentiality agreements in place. But if not, then it's always a good idea when you're working on any kind of research project to have the team members with you sign confidentiality agreements. What you don't want to do is sign it to a point where nobody can talk to anybody. You want to make sure that there's some sort of mechanism where there's an agreement that this is how it gets shared with the right people.
Mm-hmm. And our last question, that's a bit of a follow-up to previous ones we've asked already, is do I need to have team members who have participated in inventing the IP sign something that says they will fill out forms in the future that, you know, as things are created and developed, that they need to sign certain things in the future?
So that's always a good rule. Companies use that rule all the time. When anyone enters Pratt & Whitney, they do sign that agreement saying that they will support the application process, and they'll sign whatever documents are necessary. That's always a good rule to have in place.
Okay. Sorry, and just one last question.
No, we have plenty of time.
What happens if a person who signs the patent application leaves the company? Should we have an agreement where they give us power of attorney if they leave? What's the process?
So the process is usually that you have to stay in touch with that person somehow, and they have to they support the application process throughout. So the invention is made, and the person leaves the company, but the agreement that we had with them when they came in was they'd still support the signing and the they would still contribute to preparing the application and anything we needed from them in the prosecution process. So just because they leave the company doesn't mean that they're out of the application process. In the US, the inventor has to be part of it throughout.
And these documents, sort of asking a person to support us through the entire process after they leave, while they're at the organization, et cetera, can all be developed by the patent attorney that we've engaged to actually file our patents?
Yes.
Okay.
Absolutely.
Great. Well, thank you so much, Raja. That's all of the questions we have right now. We'll certainly share with you more questions should they come in. And I'll pass it over to Gwen for any final words.
Thank you, Nidhi, and thank you so very much, Raja. Your master lecture was illuminating and will be incredibly helpful to all of our teams who are in the process now of actually protecting their intellectual property. So you've given them a wealth of information. Thank you very, very much for that. So too, GoFly teams, please note that we have some intellectual property mentors, as Raja referred himself in his lecture to some of his colleagues. We have IP mentors for you should you need help as well in that arena. So you all know you can click on the request a mentor form on the website, and we will match you that way. So thank you all. Happy holidays all, and a very special thank you to Pratt & Whitney today, and specifically to Raja for an incredibly informative master lecture. Thanks so much.
Thank you. Have a great day.
Thank you so much.